Most drivers make a critical mistake the second a police officer says, "Step out of the vehicle." If you follow that order without saying these specific phrases first, you might be unknowingly waiving your Fourth Amendment protections before your feet even hit the pavement. And here is the part that will shock you. You are legally required to get out of the car. There's a 1977 Supreme Court decision that settles that question permanently. But what that ruling does not take away, what no officer and no court can strip from you, is what you say, what you do not say, and what you refuse to consent to the moment that door opens. Stay with me, because by the end of this video, you will have a word-for-word script to use at your next traffic stop, one that is backed by constitutional law, tested in courtrooms, and designed to keep you both safe and protected. This is legal logic. Let's get into it. Before we get to the phrases that protect you, you need to understand the legal landscape you are operating in. Because if you walk into a traffic stop thinking you can just refuse to exit, that belief will get you arrested within 60 seconds. In 1977, the United States Supreme Court handed down a unanimous decision in Pennsylvania v. Mimms, 434 U.S. 106. Here is exactly what happened. Two Philadelphia police officers pulled over a driver named Harry Mimms for a routine expired license plate. One officer approached the car and asked Mimms to step out of the vehicle. When Mimms exited, the officer noticed a large bulge under his jacket. A pat-down revealed a loaded .38 caliber revolver. Mimms was arrested and convicted for carrying a concealed deadly weapon. The case eventually made it all the way to the Supreme Court. The central question: does an officer ordering a driver out of a vehicle during a lawful traffic stop violate the Fourth Amendment? The court said no. The court ruled that once a motor vehicle has been lawfully detained for a traffic violation, police officers may order the driver to get out of the vehicle, period. The court weighed what it called the de minimis inconvenience, meaning minimal, against the very real danger officers face during traffic stops. The ruling noted that statistically, approximately 10% of felonious killings of police officers occurred during traffic pursuits and stops. The court concluded that the government's interest in officer safety is both legitimate and weighty, and it outweighs the minor inconvenience of asking a driver to step outside. 20 years later, in Maryland v. Wilson, in 1997, the Supreme Court extended this ruling. Officers can now order passengers, not just drivers, to exit a vehicle during a lawful stop, with no individualized suspicion required. So let's be crystal clear right now. You must exit the vehicle when ordered to do so. Refusing that direct order will result in immediate arrest for obstruction, resisting, or failure to comply, depending on your state. Do not test this. Do not argue this on the side of the road. The side of the road is not where you win this fight. The courtroom is where you win this fight. But here is the critical nuance that most people completely miss, and this is where your rights begin, not end. The Mimms ruling only gives officers the authority to order you out of the car. It does not give them the authority to search you, search your vehicle, or detain you indefinitely without cause. Those are entirely separate legal issues, governed by entirely separate rules. And those rules, they are still completely in your favor if you know the right words to say. Before your hand even touches that door handle, you have two objectives. Number one, establish the legal nature of this stop on the record. Number two, get the officer's justification for the exit order documented, whether on your dash cam, your phone, or in the memory of every witness present. Here is the first phrase you need in your arsenal. Am I being detained, or am I free to go? This is not just a question. This is a legal checkpoint. When you ask this, you are forcing the officer to define the legal status of your encounter. Are you being seized under the Fourth Amendment, or is this a voluntary encounter? Those two categories carry completely different legal rights and consequences. If you are being detained, which during a traffic stop you almost certainly are, the officer must have a lawful, articulable reason for that detention. If you are free to go, then you leave politely and immediately. This one question puts the entire interaction on a legal footing from the very first word. Now, once the officer confirms you are being detained and orders you out of the car, follow immediately with your second phrase. Officer, for my safety and yours, what is the specific reason you are asking me to exit the vehicle? Notice the framing. You are not combative. You are not accusing the officer of anything. You are invoking a mutual safety framework, which mirrors the exact language the Supreme Court used in Mimms itself. The court grounded the exit order in officer safety. So when you reference both your safety and the officer's, you are speaking directly to the legal justification the court recognized. Why does this matter? Because the officer's answer, or their silence, becomes part of your legal record. If the exit order was arbitrary, if the officer cannot articulate a specific safety or investigatory reason, that gap becomes ammunition for your defense attorney later. If the officer gives a reason, you now know the scope of what they believe they are investigating. You are not being difficult, you are being legally precise. There is a profound difference. Document everything. If your phone is accessible, let it run openly. In the vast majority of states, you have a First Amendment right to record police officers performing their public duties. Do not hide the camera, do not be deceptive. Simply let it run and let the record speak for itself. Now we reach the single most important legal action you will take in this entire encounter, and most people skip it entirely, not because they want to give up their rights, but because nobody told them they had to say it out loud. As you open that car door to comply with the exit order, you say these words clearly and calmly. I am exiting the vehicle because I am being ordered to do so. I do not consent to any searches of my person or my vehicle. Write that down. Memorize it. This sentence is doing enormous legal work. Here's why it matters so much. Your Fourth Amendment right protects you against unreasonable searches and seizures. Officers need either a warrant, probable cause, or your consent to search. They don't have a warrant, and if they don't yet have probable cause, your consent is the last tool available to them. Here's the dark truth about how consent searches work in practice. Police don't have to tell you that you have the right to refuse. They can simply ask, "Mind if I look around?" or even start moving toward the car. Many people, out of nervousness or a desire to seem cooperative, either say yes or say nothing, and silence combined with compliance can be interpreted as implied consent in some jurisdictions. By stating your non-consent explicitly and out loud on the record, you slam that door shut. Any evidence found in a subsequent warrantless search becomes challengeable. Your attorney can argue suppression. The entire case can unravel because you said 17 words before stepping out of a car. Now, and this is crucial, after you exit the vehicle, lock the door behind you and roll up the windows if you are able to do so safely, and the officer has not already prohibited it. Why? Because one of the most common tactics used to justify a warrantless vehicle search is the plain view doctrine. If an officer can see something questionable through your window, even something completely innocent that they choose to characterize as suspicious, that observation can be used to establish the probable cause needed for a full search. A rolled-up window limits plain view exposure. A locked door reinforces your non-consent. Similarly, be aware of the alert justification. If a drug detection canine is brought to your vehicle and alerts, courts have generally ruled that this provides probable cause for a search irregardless of your stated non-consent. Floria v. Harris in 2013 established that a reliable drug detection dog's alert is sufficient to establish probable cause. This is why your non-consent statement must be made clearly before any canine is deployed. It documents that any subsequent search was not based on your cooperation. You are now outside the car. You have stated your non-consent, you have your camera running, you are in compliance with the lawful exit order. Every movement you make outside that vehicle will be observed, interpreted, and potentially used to justify the officer's next action. This is not paranoia. This is simply how the legal machinery of a traffic stop works. So make your movements deliberate, visible, and verbally announced. Keep your hands visible at all times. The moment you exit the vehicle, your hands go where the officer can see them. If you need to reach for something, your phone, your registration, anything, you announce it first. "Officer, I am going to reach into my back pocket to get my registration. Is that okay?" This announcement eliminates the officer safety justification that would allow for a Terry frisk, a pat-down for weapons, under Terry versus Ohio from 1968. An officer may conduct a brief pat-down if they have reasonable, articulable suspicion that you are armed and dangerous. Sudden or unexplained movements feed that justification. Verbal announcements diffuse it. After exiting, move toward the rear of your vehicle, near the trunk area, or toward the curb, away from traffic and away from the immediate vicinity of your car door. There are two reasons for this. First, it keeps you at a safer distance from passing vehicles. Second, it physically separates you from your vehicle in a way that makes it harder for an officer to claim your movements near the car justify additional investigation. If your phone is recording, place it or hold it in a position where it captures both your actions and the officer's conduct. Dash cams are ideal because they run automatically, but a phone propped against your side mirror or held steady in your hand works. The goal is an uninterrupted visual record. Courts have upheld the admissibility of civilian recordings of police encounters in virtually every jurisdiction. This footage has literally changed the outcome of cases. Stay calm. Keep your voice level and your tone neutral. You are not performing outrage. You are building a legal record. Every word you say should be something your attorney will be proud to play in a courtroom. You are outside the car. Your non-consent is on the record. Your movements are documented. Now comes the phase where more cases are won and lost than any other. What you say next. The answer, legally, is as little as possible, and you need to say that out loud. After exiting the vehicle, invoke your Fifth Amendment right with this exact language. "I am going to remain silent and I want my attorney." Why these exact words? Because of a 2013 Supreme Court ruling that most people have never heard of, Salinas v. Texas, 570 U.S. 178. The court held that simply remaining silent is not enough to invoke your Fifth Amendment protections. If you just go quiet, if you just stop answering questions, that silence can actually be used against you as evidence of guilt at trial. You must explicitly claim the privilege. The right to remain silent is, in the court's own words, not self-executing. You have to claim it out loud. Once you say those words, "I am going to remain silent and I want my attorney," you have created a constitutional wall that prosecutors cannot breach without significant legal risk. Now let's address some specific questions officers commonly ask after the exit order, questions that feel routine but are legal tripwires. Where are you coming from? You do not have to answer this. It is not required by law. A polite, firm response, "I am choosing to remain silent." Have you been drinking tonight? You do not have to answer this. However, be aware that in every state, if you are arrested on suspicion of DUI, implied consent laws mean your refusal to submit to a chemical test after arrest carries its own legal consequences, including automatic license suspension. This is different from answering questions. Know the distinction. Can you walk a straight line for me? Field sobriety tests are generally voluntary. You are not legally required to perform them in most states. You may decline. Step over here for me. If an officer asks you to physically move somewhere, it is legally safest to comply while verbally noting, "I am complying under protest and I do not consent to any searches of my person or my vehicle." Here is the key principle that ties everything together. You cannot effectively fight a case on the side of the road. The roadside is not your courtroom. The roadside is a high-stress environment where adrenaline is running, cameras are rolling, and every word is being documented. Your goal at the traffic stop is simple. Comply with lawful orders, state your non-consent clearly, invoke your Fifth Amendment right explicitly, document everything, and then let your attorney fight the battle in the place where the battle can actually be won. Rights are not just words printed in a constitution. Rights are what you assert, what you document, and what your attorney argues on your behalf when the stakes are real. Let's recap the 5 things you do the next time an officer orders you out of the car. 1. Ask, "Am I being detained or am I free to go?" 2. Ask, "Officer, for my safety and yours, what is the specific reason for the exit order?" 3. State clearly as you exit, I am exiting because I am ordered to. I do not consent to any searches of my person or my vehicle. 4. Lock your car, keep your hands visible, announce every movement, and record the interaction. 5. Say, I am going to remain silent and I want my attorney, and then honor that statement. That's it. 5 actions, a handful of sentences. The difference between a case that gets thrown out and a conviction built on what you unknowingly handed over on the side of a highway. If this video gave you something you didn't know before, a legal edge, a clearer picture of your rights, share it with someone who needs it. Drop your questions in the comments. I read every single one, and your question might become the next video. This is Legal Logic. Know the law, use the law. See you in the next one.